Hi guys, it's Kathy. I hope you're doing well. We made it to Saturday. Woo. Today's gonna be a long day, guys. But that's okay. Tomorrow's Sunday. Tomorrow, and this is very wholesome. I don't know if I told you or not. My job is doing a flag football game tomorrow. I'm gonna go watch. I'm not gonna participate. We were cleaning the dining room. It was me and another server cleaning the dining room a couple days ago, and she's in her 20s and I'm me, and the chef comes out and he goes to her and he's like, Abby, you're gonna play flag football with us? She says, no, can't play flag football. He's like, come on, it'll be fun, blah blah blah. And I don't know, I think he talked her into it. I don't know, I think. And I'm like right with them. I'm sweeping, and then I said, I'm gonna come and watch. And she says, hey, why aren't you asking her to play? I'm like, me? My hips are way too old for that. I would need a new hip. If I played flag football. If I played football, though, I would want to tackle someone. Right? Wouldn't you want to tackle someone if you're going to play football? Flag football. But I'm okay, Kelly. I'm tired. People get tired. I'm tired. It's fine. That means I worked hard. I did work hard yesterday. I got a new judge today, nope, that's not right. Bradley Burback. Bill's tired. Bill, go to bed. Why are you awake so early? Oh, forgot to. Oh, I put so many images up here now. I don't know which one is Bill. Nope. How'd that get there? Interesting. Oh no, Oh, Bill, I thought I lost your image. You're number one. You're the first image. All the other ones I clicked, image 2, image 3. You are number 1. It's Bill. Hi, Bill. Drinking and driving. You're going to Texas, I see. I see you're going to Texas. So we're just going to watch a jail calendar from Colorado because it looked interesting. I don't know. I didn't listen to it. Yeah, Kay, why do we do that? Wake up at 4 o'clock in the morning. I didn't. CJ had to wake me up today. Thank you, CJ. Let's press play.
Here 2601
we go.
People State Colorado versus Alex Vogelsang.
Good morning, Your Honor. Claire Elster on behalf of Mr. Vogelsang, who is present in person, and we have reached a proposed disposition subject to the court's approval.
And Joe Scheitler on behalf of the people.
All right, thank you. Good morning, Mr. Vogelsang. A proposed disposition, my understanding is Mr. Vogelsang pleading guilty to an added count 2 of attempted harassment, strike, shove, kick, class 2 misdemeanor with a factual basis of domestic violence. Count 1 would then be dismissed. Ms. Elster, is that your understanding?
It is, Your Honor.
Thank you, Mr. Vogelsang. Is this your understanding as well?
Yes, sir.
All right, and Mr. Vogelsang, we have a, looks like we have that electronically filed, okay. Looks like we do have a rights advisement that's been electronically filed in the case. And Mr. Vogelsang, did you go over that rights advisement along with your attorney?
Yes.
You understand what your rights are?
Yes.
Any questions about your rights?
Sure.
And you understand pleading guilty means you're giving up your right to have a trial?
Yes, sir.
Is that what you want to do?
Yes.
Have you had enough time to discuss the case with your attorney?
Yes.
And are you satisfied with her advice?
Yes.
All right, sir, did anybody force you or threaten you or put any kind of pressure on you to get you to plead guilty?
No.
Were any promises made that we haven't talked about to get you to plead guilty?
No, sir.
And today, are you under the influence of medication or anything else?
No.
So is your mind clear? Do you understand what you're doing?
Yes.
And is this a free and voluntary decision that you're making to plead guilty?
Yes.
All right, again, the charge you're pleading guilty to is attempted harassment, Class 2 misdemeanor, with a factual basis of domestic violence. Do you understand that charge?
Yes.
And do you wish to plead guilty to that charge?
Yes.
Do you understand the possible sentence that could be imposed?
Yes.
And you understand that by agreeing to a factual basis of domestic violence in the case, that your future ability to purchase, own, or control firearms or ammunition would be prohibited?
Yes.
Understanding that, do you still wish to plead guilty?
Yes.
Counsel, is there anything further you'd like me to advise your client?
No, Your Honor.
And do you stipulate to a factual basis and a factual basis of domestic violence?
Yes, Your Honor.
Thank you. Any victims' rights record from the people?
Yes, Your Honor. My colleague was able to speak to the named victim here. We are VRA compliant when it comes to this offer.
Hi, Tina.
In regard to sentencing today,
Mhm.
we have advised her of that the defendant would be taking this today. It was, I believe that she told our office that she's intending to appear virtually today. I do not see her on WebEx, but we are prepared to go to immediate sentencing.
CJ,
All right,
thank you.
thank you. Find compliance with
Thank
victims'
you,
rights for
CJ. Thank
purposes
you.
of the plea. All right, then, Mr. Vogelsang, to the added count 2 of attempted harassment, factual basis of domestic violence. How do you plead, guilty or not guilty? Court finds Mr. Vogelsang has been advised of his rights. He's been represented by competent counsel, and that he is making a free, voluntary, knowing, and intelligent decision to plead guilty today. He has not been subjected to any undue influence, force, threats, coercion, or promises.
Hey, Bill, don't listen to Martha. Oh no, my mic, my camera. Bill, don't listen to Martha. Go faster. Martha, I'm joking. I'm joking. Be careful, Bill.
He's not under the influence of medication or anything else. His mind is clear and he understands what he's doing here today. Factual basis has been stipulated, including a factual basis of domestic violence. Court accepts the plea of guilty to the added count 2, finding it to be voluntary. Count 1 is dismissed. And I do make findings of domestic violence pursuant to 18-6-800.3. Sounds like the parties are asking for immediate sentencing and we're victims' rights compliant to do that. Is that correct?
Yes, Your Honor.
All right, people's position on sentencing.
Yes, Your Honor. I'm not sure if the court has been able to review the affidavit in this matter, but touching on a factual basis here, this event occurred on April 7th of this year. Approximately midnight, agents were dispatched at 401 Zhang Street in the city of Lakewood in reference to a domestic disturbance at the residence. Neighbors called in reporting a male and female yelling at each other outside their apartment. Upon arrival, agents contacted female at the door of the residence, Miss McKenzie. When she exited, the door shut behind her. And the defendant was telling police he did not want to speak with them and to contact his lawyer. The named victim here willingly spoke with agents, and through that, they learned that the two of them had been in arguments since leaving Topgolf earlier in the night. When they got home, the argument continued. She described that she was trying to get away from him to get space by doing so in their shared bathroom. Well, in that bathroom, the defendant was spitting on her, and he was uncooperative through the investigation on scene and would not allow agents into their apartment, telling them to leave. Agents were able to get Miss McKenzie a safe place to stay that night. Law enforcement then made contact with the defendant on the 18th of April. He made it very clear that he did not want to speak with police about what had happened that night, advising them to contact his attorney. Then agents on the 22nd of April were able to make contact with the victim.
Pope Phil, I haven't seen you in a while. It's nice to see you again, Pope.
And by phone, she agreed to speak with him about the
It was a
night
bad joke.
and advised that she is no longer in a relationship with the defendant and has since moved out of the apartment. She went into greater detail in terms of what happened. They were at Topgolf. She said that the defendant was intoxicated, and while she was driving on the highway, he tried to take a hold of her steering wheel multiple times and tried swerving her car while she was driving. She could not recall specifically what highway this occurred on. When they got home, she said they had to climb through a window because they had lost the keys, and she had tried to get space from him by going into the bathroom to run a bath. She said she put a box of kitty litter in front of the door and inside the bathroom to keep the defendant from coming in, since the door to this bathroom does not lock. However, the defendant still managed to push open the door and deliberately spit on her in the face, aiming for her face, but it did not land on her face. She estimated this did last for she estimated that he did this approximately 3 times. One of the times where he opened the door to spit on her, she tossed a cup of water at him to get him to stop spitting on her. She also mentioned that this was not the first time the defendant had spit on her, and talked about another time in public when he did spit on her and no one around her reacted, and she was left shocked. And then in regard to and the named victim also had screen recordings and audio recordings from the night of the 7th and a few days during the breakup. She submitted a screen recording from Snapchat audio recordings from the night of that incident while they were driving the car. The defendant can be heard yelling multiple times and had a very noticeable slurred speech as if he was intoxicated. In the last recording from this video, the defendant discovered that the victim was recording and became angry and started yelling "fuck" multiple times before the recording stopped. The named victim also uploaded a photo of her arm from the incident she described occurred in Denver, in which the defendant allegedly bit her. This was also unreported to law enforcement as well. Looking at the defendant's criminal history, Your Honor, this is pretty much the first incident of, I guess, first conviction for domestic violence. The only other prior I'm seeing is leaving the scene of an accident of an unintended vehicle back in 2022. I think that the concern here, Your Honor, is obviously the defendant's age and his behaviors here.
Yo, I agree, Kelly.
I believe he's only 21 years old. With that being said, the people would be requesting 18 months of probation with domestic violence evaluation and treatment, along with monitored sobriety. I believe that due to the defendant being intoxicated as well, substance abuse evaluation and treatment, I think that's important that the defendant engages in this treatment to curb this behavior going forward. I believe that the victim would echo these requests. I would point out to her victim impact statement as well that it is unfortunate because this crime left her feeling insignificant. There were times it was publicly abusive and people just watched. It also left me with fear and depression. She also cites a bruise and bite marks on her left arm as injuries that she sustained as a result of this crime. And in regard to what could be done to assist in repairing the harm inflicted on her, she said, "Unfortunately, I feel nothing." I just think that this just plays into those unfortunate dynamics of a domestic violence relationship. It's good to hear that they're no longer together, but at the end of the day, I just hope that this probationary term encourages the defendant to take a look at himself in how he treats women.
All right, thank you, Ms. Elster.
Yes, Your Honor, thank you. We do believe this is an appropriate disposition for Mr. Vogelsang. Just to correct the record, the bruise and bite marks are not charged conduct in this case. Those were separately charged conduct based on an allegation from something that happened in
We
Denver
know.
County.
We
So
heard.
those are not a part of the charged conduct
Good to
here.
point that
Just to
out.
clarify the record. However, Mr. Vogelsang is here, willing, able, honest, and prepared to admit his guilt in this situation. This was a toxic relationship for both parties. Since the date of this offense, Mr. Vogelsang has since married a different party. So he has moved on with his life. He has also been on pretrial services with monitored sobriety
Can you check her for bite marks? Is she there? Can I see her for a second?
for 5 months in this case with absolutely zero violations. He's been in full compliance with that as well. So he is understanding that there was allegations of alcohol involvement, that he was using alcohol, which caused him to act outside of his normal character. But he has been able to address his drinking and maintain complete sobriety. Furthermore, he's already enrolled in and begun the process to begin the domestic violence treatment. So he's already taken a necessary step in that right direction. So we do believe that Mr. Vogelsang will be able to comply with monitored sobriety, complete his domestic violence classes, learn from those classes, and not be back in front of this court again.
All right, thank you. Is there still a pending case in Denver? or-
That case was resolved. He pled guilty to disturbing the peace.
All right, thank you. Mr. Vogelsang, was there anything you wanted to add or anything that you think I should know?
No, sir.
All right, Mr. Vogelsang's pled
Mr.
guilty
Vogel,
to
do
the
you want to bite
attempted
the judge?
harassment factual basis of domestic violence charge, and I have reviewed the affidavit, the victim impact statement, and heard the sentencing arguments made today. Obviously concerning Mr. Vogelsang that this was the kind of relationship that resulted in this, but you have taken responsibility by pleading guilty here today. And it does not appear, other than the one that happened in Denver, that there's any other incidents of domestic violence or
Other
assaultive
than
type
that
behavior
one.
in your history. You're 21, is that right, Mr. Vogelsang?
Yes, sir.
Okay, well, I'm hoping that this was just youthful indiscretion and youthful decision-making and just not being in control of your emotions, which is something we see a lot in people who are the age that you're at. We see it in people older than you, certainly, but your brain is still developing, and sometimes there's impulsivity and acting impulsively. And I'm guessing maybe that played a role along with alcohol use. And sounds like you've been candid about alcohol use being involved in this. Is that right?
Yes, sir.
Okay, well, hopefully probation will do what it's supposed to do, Mr. Vogelsang, which is to address whatever the issues are, make sure this doesn't happen again. I'm glad it wasn't any worse than it was. Obviously, it had a pretty significant impact on the victim in the case, and I'm taking that seriously. And frankly, if she'd asked for a jail sentence, Mr. Vogelsang, I'd probably be giving you a jail sentence as a condition of your probation, but she didn't ask for that. So apparently she has moved on with her life. Sounds like you moved on with your life. And lesson learned, obviously you can't treat people this way, Mr. Vogelsang. I'm guessing you know that by now, right? So I'm assuming this is a one-time isolated event and we'll address it and not have you come back. So I do think probation is appropriate. It is a first domestic violence conviction. So I'll place Mr. Vogelsang on probation in the case for a period of 18 months with standard terms and conditions of probation. Terms and conditions include no drug or alcohol use. Substance abuse evaluation is ordered, Mr. Vogelsang to comply with the recommendations, including recommendations for treatment. Monitored sobriety ordered for the duration of probation. No weapons is a condition of probation and as required by statute. Relinquishment of firearms ammunition is a condition. And because there was a factual basis of domestic violence treatment and counseling is ordered, the level and duration of that to be determined by probation. And the protection order does remain in effect throughout the pendency of the sentence. Anything further from the people?
No, Your Honor.
Anything further from the defense?
Your Honor, just procedurally, we added this on today for a disposition. He did previously have a pretrial conference set for next week. Just ask that that be vacated.
Sure, we'll vacate that pretrial conference. And Mr. Vogelsang, do you have any questions about any of this?
No, sir.
Good luck. I'll tell you what I tell everyone with regard to probation. The key to that is having good communication with them. So make sure you're talking to them. They know what your circumstances are. They know how to get a hold of you if they need to. And if you start having any kind of issue or concern, please be proactive in addressing that with probation. Don't spring a surprise on them like on a Friday afternoon to say, hey, by the way, I'm going on a vacation for the next 2 weeks and I'm going to be out of town. They don't tend to react very well to those types of surprises. So just make sure that you're talking to them. They know what your circumstances are. Hopefully we get you through it successfully, okay?
Thank you.
All right, take care. Stand by for some paperwork. This is case 17M 1982, People of the State of Colorado versus Desiree Rose.
And Joe Scheidler on behalf of the people.
Thank you. Okay, we'll have to pass Ms. Rose's case till Mr. Collard returns. This
Okay.
is 25M 958, People.
I wish everybody who doesn't live in Pennsylvania or up north could understand what you just said right there. Because going outside 37 degrees, it does, whew, it does. It wakes you up. It invigorates you. It's lovely.
People of the State of Colorado versus Gerardo Avila.
Raquel de los Santos for the People practicing under the Student Practice Act.
Robbie Nikon on behalf of Mr. Avila. He joins me at the podium to my right.
All right, thank you. Good morning, Mr. Avila. Matter set for pretrial conference today. I'm not seeing a disposition at this point. And Mr. Nikon, how would you like to proceed?
We'd be asking for a continuance today with a waiver of speedy trial. The reason that we asked to have this case called up is that Mr. Avila has been sentenced in a separate case. It's a DOC sentence that he will begin serving by our next court date. So we'd just be asking for a writ at our next court date from DOC.
All right, thank you. Any objection to a continuance of the pretrial?
No, Your Honor.
All right, so, Mr. Avila, my understanding, sir, is you want to waive your right to speedy trial in this case and have the case reset. Is that what you want to do, sir?
Yes, sir.
Are you doing that freely and voluntarily, Mr. Avila?
Yes.
All right, thank you. Do find a waiver of speedy trial. Set the matter for a continued pretrial. DA to do a video writ from DOC.
Yes, Judge.
All right, DA to do a video writ from DOC. We'll see what date we can clear.
Let's do December.
December 9th at 9.
We can accept that.
All right, anything further then?
Not from the defense.
Not from the People.
All right, good luck to you, Mr. Avila. We'll have you sign your setting slip for your next court date. We'll get you on your way. Take care.
Thank you, sir.
Yes.
Managed to punch a hole in the pavement.
Judge, sorry, my client just corrected me. It's not a DOC sentence. I saw CR and assumed it's actually county,
Which county, I'm sorry?
Adams County. Okay, just wanted to make sure we get the right. I'm sorry about that.
Okay, so a writ from Adams County.
All right, thank
Okay,
you.
Thank you. This is 25T 5026, People of the State of Colorado versus Terrence Horton.
Raquel de los Santos for the People practicing under the Student Practice Act.
Thank you. Mr. Horton, good morning, sir.
Good morning.
Do you have an attorney representing you in the case?
No, I don't.
All right, we were set for a pretrial conference today. I'm not seeing a disposition at this point. And are you planning on getting an attorney, Mr. Horton?
I possibly might go talk to one.
All right, Were you thinking of applying for the public defender or hiring private counsel?
Private counsel.
All right, sir. Well, you need to start doing that immediately if you're going to get an attorney. Obviously, the sooner the better. I know that can be a complicated process, but still, they need to get on the case and talk to the DA and get discovery and talk to you. Sounds like you're asking for a continuance, so you have time to check into getting an attorney. Is that right, sir?
Actually, I think we just go ahead and set it for trial, Your Honor.
Are you planning then on representing yourself at trial, Mr. Horton?
At this point in time, yes.
All right, sir. When someone says they want to represent
I
themselves
support
at
your
trial, I have to
decision,
have the
sir.
following conversation with them. You understand, sir, you have the right to have an attorney represent you in the case, but you can proceed without an attorney if you decide to. There's no requirement that you have a lawyer. However, if you do go without an attorney, then you are bound by the rules of evidence and the rules of procedure that govern trials in the courts. And I can't tell you what those rules are. A lot of people, when they represent themselves, expect me to help them and tell them what to do, which I cannot do. So, do you have any legal education or background, Mr. Horton?
No,
All right, sir. And have you ever represented yourself at a trial before?
no.
Okay. And again, sounds like you might want to be trying to get an attorney, and obviously you can do that at any point. But since you want to set the matter directly for trial at this point, since we don't have an attorney's calendar, we'll have to set it. And then if an attorney later enters on the case, then we can always talk about a resetting of that date. But sounds like that's what you want to do, Mr. Horton? Or do you want to continue us to look into getting it?
Let's go ahead and do a continuance, Honor. I'll go
Okay.
talk to an attorney.
All right, well, that's probably a good idea. Did you want to waive speedy trial here today, Mr. Horton, so you have some more time to get an attorney, more time for the attorney to get on the case?
Yeah,
Are you
Please.
doing that freely and voluntarily, sir?
Yeah.
All right, do find a waiver of speedy trial by Mr. Horton. Do the people have any objection to a continued pretrial entry of appearance at council?
No, Your Honor.
All right, well, again, we got to pick a date. Don't have your attorney's calendar if an attorney's going to enter on the case, but if an attorney does enter and that date doesn't work, they can let us know. So we'll see what date we can clear for a continued pretrial and entry of appearance at council with speedy trial being waived today. December 9th at 10. All right, sir, any
You
questions
heard
about any of
who.
this?
I don't.
All right, good luck to you, Mr. Horton. We'll have you step over here, sign the setting slip for that date. We'll see you next month.
Thank you.
Take care.
Pope, I did the same thing when I heard his voice.
like 2 minutes. Yeah. Okay, yeah. Sounds good. 2 minutes. I can do it.
So I have a snow scraper, obviously. I live in Pennsylvania.
Oop.
But I almost always use my driver's license. It just works so much better, especially for frost. It just scrapes it off so easy. Just remember that if you want to clean your windshield, use your driver's license.
This is 25M 5218, People of the State of Colorado versus Michael Segala. Mr. Segala, good morning.
Good morning.
Is Mr. Nikon your attorney?
Yeah, I believe so.
Thank you. Stand by just a second, Mr. Segala. I think we're
Water would just freeze. Even if it's hot, it doesn't stay hot long.
And Joe Schuyler on behalf of the people.
Thank you, Mr. Schuyler. And Mr. Nikon with Mr. Segala.
Robbie Nikon. I'm appearing with Mr. Segala. Mr. Segala was represented by me when he was in custody. He's been operating under the assumption that I'm still his attorney. He even went to the public defender's office. We're just waiting on an application. So I'm appearing with Mr. Segala today.
Okay, thank you. Looks like Mr. Segala has
I identify as his attorney, Judge.
submitted an application for the public defender's representation. And the indication I have is he does qualify for court-appointed counsel. So with that being said, Mr. Nikon, we're set for an arraignment today. I'm sort of guessing maybe you're going to ask for a continuance of the arraignment so you have time to get on the case.
Yes, Judge. The main reason we wanted it called was because there are several protection orders in the case. We'd be asking to address the protection order that bars him from contact with the mother of his children. Depending on the court's ruling with respect to the protection order, we might be asking for a continuance or might be asking to enter a not guilty plea.
All right, well, with regard to any issue pertaining to the protection orders, are we victims' rights compliant?
We are, Your Honor.
All right, and Mr. Nikon, specifically, what's the request?
Judge, we'd be asking that Mr. Segala be able to contact the alleged victim in this case. I understand that the alleged victim is asking for full contact, and we are supportive of that. Reason being is that they say they share 3 children together, and it's been very burdensome on their family to have this protection order. It's effectively prevented Mr. Segala from being able to parent his 3 children. If the court will not allow full contact at this time, we would be asking for electronic communication at a minimum.
All right, thank you. And I'm guessing it's the protection order naming Bernadette Segala as the protected party.
Yes, Your Honor.
I'm still going to say, Pope, that anything with water, because it's cold. It's just so cold. I don't know. I just take my driver's license and it's fine.
All right, with that record, people's position and victims' rights.
Yes, Your Honor. My colleague was able to speak with the named victim here. In regard to the modification and protection order, she says that she needs the protection order lifted. She said that they have 3 kids together. Drop-offs are being done through mom. And I guess in essence, to everything at hand, she wants all this to go away. In regard to the people's position, Your Honor, at this time, I wouldn't be objecting to electronic communication, given that they do share 3 kids. I guess the biggest concern here, Your Honor, is that looking at the affidavit is that this case arose during a child custody exchange. Given that we are here on a second arraignment, I believe that there needs to be more time, proof of enrollment in treatment or some other mitigating factors to modify for full contact.
All right, thank you. I note there's another case out of Adams County, which is 25M 4507, currently set for a motions hearing on January 5th of next year. Looks as though the protection order in that case was modified on October 31st to lift the no contact provisions, so it doesn't appear as though we would have a conflicting protection order in place. But based on the circumstances, I'm just going to modify it for electronic written contact pertaining to the children. Other provisions, however, do remain in full force in effect. With that being done, Mr. Nikon, how did you want to proceed?
We'd ask to enter a not guilty plea today. We'd also ask that the people be compliant with VRA to address the protection order again. We understand the court's ruling today. We'd hope that with more protective factors, the court would be willing to modify the protection order to mirror the Adams County protection order.
All right, thank you. Not guilty plea enters, and we'll set a case for a pretrial conference. December 12th at 8. Anything further from either side?
No, Your Honor, I just wanted to clarify the modification is electronic written communication about the.
Electronic and written contact regarding the children.
Perfect, thank you.
Sure. Anything further, Mr. Nikon?
Not at this time.
Okay, good luck, Mr. Segala. We'll have you sign your setting slip for your next court date. We'll get you out of here. Take care. This is 25M 3126, People of the State of Colorado versus Michael Bomboy.
Dan Pomerantz on behalf of people. Morning, Your Honor.
Ring.
Morgan Trucks on behalf of Mr. Pomboy, who appears in custody at DOC via WebEx, Parks and Student Parks Act, being supervised by Mr. Nikon.
All right, thank you. And Mr. Bomboy, good morning. Can you hear me, sir?
Your Honor.
Thank you. Looks as though we have a proposed disposition in this case. My understanding, Mr. Bomboy pleading guilty to count 3, possession of a financial transaction device, Class 2 misdemeanor. Counts 1 and 2 would then be dismissed. People have no objection to a 30-day jail sentence to run concurrent with the DOC sentence.
Credit card?
Ms.
think?
Truax, is that your understanding?
Yes, Your Honor.
Thank you. Mr. Bomboy, is this your understanding as well?
Yes, Your Honor.
All right, and I do have filed in the case, sir, a rights advisement. Did you go over that rights advisement along with your attorney?
Yes, Your Honor.
You understand what your rights are?
I do.
Do you have any questions about your rights?
No, sir.
And you understand?
So you can tell this is not all from the same county. And I don't know what county we're in Colorado. Because we have orange, we have someone in red. It looks like we have 2 people in dark blue and 1 person in a bright green, yellow. And these aren't sentences. So I don't think there's time for someone to be, like I can't remember the word. It's just not even, it's not going to come to me. When they're a trustee in jail. So they have to just be from different counties and they have different colors.
Sir, pleading guilty means you're giving up your right to have a trial.
I do.
And is that what you want to do?
Yes, Your Honor.
Well,
Have
he
you
has
had
taken
enough
a
time to
plea.
discuss the case with your attorney?
Yes.
And are you satisfied with her advice?
Yes.
All right, sir. Did anybody force you, threaten you, or put any kind of pressure on you to get you to plead guilty?
No, sir.
Anyone make any promises that we haven't talked about to get you to plead guilty?
No, sir.
And today, are you under the influence of medication? Anything else?
No.
So is your mind clear? Do you understand what you're doing?
Yes, sir.
And is this a free and voluntary decision that you're making to plead guilty?
Yes.
All right, again, sir, the charge you're pleading guilty to, possession of a financial transaction device, Class 2 misdemeanor. Do you understand that charge?
Yes, Your Honor.
And do you wish to plead guilty to that charge?
I do.
You understand the possible sentence that could be imposed?
Yes.
Counsel, anything further you'd like me to advise your client?
No, Your Honor.
All right, then, Mr. Bomboy, to count 3, possession of financial transaction device, Class 2 misdemeanor. How do you plead, guilty or not guilty?
Guilty.
Court finds Mr. Bomboy has been advised of his rights. He's been represented by competent counsel, and that he is making a free, voluntary, knowing, and intelligent decision to plead guilty today. And he has not been subjected to any undue influence, force, threats, coercion, or promises. Is not under the influence of medication or anything else. His mind's clear. He understands what he's doing here today. Sure. Did you stipulate to a factual basis, Ms. Truax?
Yes, Your Honor.
Okay, thank you. Factual basis has been stipulated. Court accepts the plea of guilty to count 3, finding it to be voluntary. Counts 1 and 2 are dismissed. And in terms of sentencing, understand the people's position. Anything further from the people?
Your Honor, I'll just note for the court that when I look up the defendant in DOC, I see that the case number is 25 CR 5172 out of Denver.
All right, and in terms of the sentence Mr. Bomboy is serving, what sentence is he serving in that case?
I believe it's an 18-month sentence, Your Honor.
All right, anything to add to that, Ms. Truax?
No, Your Honor, that's correct.
Mr. Bomboy, anything you would like to add or think I should know, sir?
No, sir.
All right, well, the case resolved with a plea of the Class 2 misdemeanor. Mr. Bomboy is serving a sentence in the Department of Corrections at this time. I will waive applicable fees and costs due to a finding of indigency and sentence Mr. Bomboy to 30 days in the county jail, which is concurrent with the DOC sentence he is serving at this time. That sentence to be served in the Department of Corrections. And that will close the case today. Mr. Bomboy, good luck.
Thank you.
Of course, yeah, Joe. It's gonna happen every time, and I'll handle it.
This is 23T 2722, People of the State of Colorado versus Jaime Lopez Martinez.
Dan Pomerantz on behalf of the people.
Robbie Nikon on behalf of Mr. Lopez Martinez. Mr. Lopez Martinez is in custody at the Jefferson County Jail. This is an interpreter matter. I've shared the number from the jail with the interpreter. So hopefully we are simultaneous.
We are, Your Honor. I'm on the phone with Mr. Lopez.
Okay, thank you. Good morning, Mr. Lopez Martinez. This is a case in which a warrant issued for failure to appear on June 30th. Bondsman set at $10,000 cash. Not seeing a disposition at this point. Mr. Nikon, how would you like to proceed?
Judge, for this revocation, we would be asking to admit today and proceed to immediate sentencing.
All right, thank you. So my understanding here, Mr. Lopez Martinez, is you want to admit to the allegations in the probation complaint. Is that what you want to do today?
Yes.
And you understand by doing that, sir, you're giving up your right to have a hearing. Did you want to give up your right to a hearing?
Yes, correct.
All right, sir, and have you had enough time to discuss the case with your attorney?
Yes.
Are you satisfied with his advice?
Hello? Yes.
All right, sir, did anybody force you, threaten you, or put any kind of pressure on you to get you to do this today?
No.
Did anyone make any promises to you to get you to do this?
No.
And today, are you under the influence of medication or anything else?
No. No, nothing.
So is your mind clear and do you understand what you're doing?
Yes.
Is this a free and voluntary decision that you're making to admit to the complaint?
Yes.
All right, so the allegations are that you did violate probation, specifically that you failed to submit to 13 UA tests, most recent as of the filing of the complaint on June 26th, July 8th, and July 9th of last year. Do you admit that that allegation is true?
Yes.
Next, that you failed to report to 3 appointments with probation, the most recent on April 11th, 25th, and July 10th of last year. Do you admit that that allegation is true?
Yes.
Next, that as of the filing of the complaint, you had failed to enroll into DUI treatment. Do you admit that that allegation is true?
Yes.
And finally, that as of the filing of the complaint, you were $183.50 in arrears regarding court fees and costs with an outstanding balance of
Thank you, thank you, thank you, thank
$183.50.
you, thank you.
Do you admit that that allegation is true?
Yes.
Counsel, anything further you'd like me to advise your client?
No, Judge.
Then the court finds that Mr. Lopez Martinez has been advised of his rights. He's been represented by competent counsel, and that he is making a free, voluntary, knowing, and intelligent decision to admit to the complaint. He has not been subjected to any undue influence, force, threats, coercion, or promises. Is not under the influence of medication or anything else. His mind's clear. He understands what he's doing here today. Court accepts the admissions, finding them to be voluntary. Do you find a violation of probation in the case? Do people have any resentencing position or any input from probation this morning?
We have both, Your Honor. Your Honor, probation is requesting we close this case with jail, given the amount of time that has passed since the defendant's been in contact with probation. The people believe that's appropriate for several reasons. First of all, as probation notes and as the court's very clear from the complaint, the defendant's been out of contact with probation for a little over a year here. So it's not particularly encouraging in terms of his ability to comply with probation and get himself straightened out. We'll also note that he has a prior DWAI offense from Summit County, that's 16 CR 156. In that case, the defendant was also unsuccessful on probation. He ended up with probation being revoked and terminated unsuccessfully. So we don't have the best we don't have the most optimistic outlook for the defendant on probation, given those two pieces of information. So that leaves us asking to close this with a jail sentence. And as far as the length, we do have to look at the nature of the behavior. This is a second offense. It's outside of 5 years, but this offense seems concerning to this deputy district attorney when I look at it. The defendant was passed out in a vehicle that was idling in a private driveway, parked not in the direction of the driveway, but parallel to the street. The defendant was very delirious on law enforcement contact. Law enforcement noticed dried vomit on the defendant's shirt and pants, observed his eyes were bloodshot and glassy, noticed a distinct odor of alcohol coming from him. The defendant admitted to drinking, quote, 3 to 4 buckets of beer, end quote, and 5 to 6 tequila and whiskey shots. Still felt that he could drive home safely. I believe he also admitted to using cocaine prior to driving at some point. So the fact that his BAC came back at a 145 was contrary to some of the indicia law enforcement observed, contrary to his own statements. It's just the people the defendant had driven and then had been idling in that driveway for some period of time. That suggests a relatively significant community safety risk. Given all of those factors, given the defendant's total lack of compliance with probation here, people are requesting a 180-day jail sentence. Thank you.
All right, thank you, Mr. Nikont.
Judge, we'd be asking that the court revoke and reinstate probation in this case. I think that there's a few reasons why my client has failed to comply with probation previously, which he has taken accountability for today. First is that he doesn't live in Jefferson County, Colorado. He lives in Summit County, and he also works in Summit County. All of his ties to the community are outside of Jefferson, which has made it challenging for him to check in with probation, especially because he doesn't drive. He uses buses to get anywhere that he goes. When I look at the procedural history of this case, I see that the 4 times that he did appear leading up to his plea, each time he was pro se. There's also a language barrier here. So no fault of the prosecutor that negotiated this plea, but I suspect they did not realize that my client didn't live in Jefferson County. And perhaps if courtesy supervision had been authorized, we'd have a better track record here. And that's what we're asking for today, Judge, because like the prosecutor, we want my client to get the treatment that he needs in this case. I understand, as the prosecutor points out, that he did previously fail probation, but I'd emphasize that that was back in 2017 when he was revoked. Since then, he has a lot more stability in his life. He has a stable job in Summit, a stable place to stay. And we're just hopeful that this time around, if the court does give him another opportunity at probation, that in Summit, he be successful this time. In this case, he has been held for 54 days. I've explained to him that if he comes back on another revocation, he will almost certainly face a long custodial sentence. He shares with me that he wants to do probation. He wants to do it in Summit, and he's just asking for that chance.
Thank you. Mr. Lopez Martinez, was there anything you wanted to say or anything else you think I should know?
Yeah, Your Honor, I just want to apologize and let you know that I'm really remorseful for not complying before, and I would really appreciate a second opportunity.
All right, thank you, Mr. Lopez Martinez. This case dates back to April of 2023. And Mr. Lopez Martinez pled guilty to driving under the influence. It was a second offense, although it was outside the 5 years. Actually, it may have pled guilty to DWAI, but it was a second offense, so it doesn't make a difference in terms of sentencing. But in any event, it was outside of 5 years. The prior case happened in 2016 out of Summit County. In that case, in 2018, it looks like probation was revoked and terminated unsuccessfully, and a jail sentence resulted. Facts of this case, the blood alcohol was, as has been stated, a 0.145, which is somewhat elevated, although it's not ridiculous or unduly alarming just based on the number. There was no accident involved in the case. Nobody got hurt. And in terms of the complaint that we've resolved here today, it is not the most aggravated complaint in the world. It's not based on a new law violation. It's just essentially Mr. Lopez Martinez not complying with probation or staying in touch with probation. I note that in this case, since April of last year, pardon me, April of this year, there's been 4 failures to appear by Mr. Lopez Martinez, which is at least arguably a concern in terms of him being able to comply with probation, although I understand the circumstances with him living in another county. And at the time of sentencing, in this case, which was back in August of 2023, I did suspend 335 days jail, impose 30 days work release initially. So there was a 335-day jail sentence that was suspended. And an argument could be made that I should just impose that 335 days and be done with the case, since it looks at least somewhat questionable as to whether or not Mr. Lopez Martinez is going to be able to comply. But again, it's not a particularly aggravated complaint, and the underlying facts are not overly aggravated either. Although I think frankly, putting Mr. Lopez Martinez back on probation is likely setting him up to fail, because I just don't think in all likelihood he's going to be able to comply with probation. And the case is getting relatively elderly since it dates back to 2023. So at this time, probation is revoked and terminated unsuccessfully. Any outstanding fees or costs are referred to civil collections. So there's 54 days of pre-sentence credit, Mr. Nikon?
Yes, Your Honor.
All right, I will sentence Mr. Lopez Martinez to 200 days in the county jail, giving credit for 54 days served.
Ouch. Whew.
And that will close out the case today. Good luck, Mr. Lopez Martinez.
Thank you.
Thanks to the interpreter.
Yeah, of course, Your Honor. There's several other cases on the docket. I don't know if any others are ready.
We may have handled a couple of them over the counter. Which cases is the interpreter referring to?
I think we're probably okay for now. I want to say we're okay. for
Okay,
now.
seems like we don't have anything pressing at the moment.
Okay, thank you, Your Honor.
Sure. Still no Mr. Collard.
I don't know why. I have no reason to know why, but I hope we get to the bottom middle square.
Fascinating show you're watching, Michelle.
Obviously, the top left square.
Of course, I gotta run over to D.
This is 24M 5422, People of the State of Colorado versus Matthew De La Cruz.
Joe handle that.
And Joe Shaler on behalf of the people.
Q, good morning, Mr. De La Cruz.
Good morning, Your Honor.
Sir, do you have an attorney representing you in the case?
No, I don't.
All right, we are set for pretrial readiness in the case today, currently set for a jury trial on November the 17th. Are the people calling ready for trial?
And Your Honor, it's kind of a unique situation here because I believe that originally the trial dates were entered as 11/7 instead of the 17th. So when our subs were sent out, they were sent out for the 7th.
I love subs.
Um,
Ham and cheese is my
as a
favorite.
result, the subpoenas that were sent, we called off law enforcement for the 7th so that at this time we cannot call ready due to that, I guess, error in terms of the scheduling here. I did speak with the defendant as well. He, based on my interpretation, he intends on representing himself on this case, has still yet to pick up any discovery when it comes to this matter as well. And I think that there's a mutual agreement in terms of resetting the trial date in this matter.
Kelly, thank you so much. Thank you, Kelly.
All right, thank you. So with that being said, Mr. De La Cruz, sounds like you're all right with resetting the trial that we had set for November 17th based on those circumstances. Is that right, sir?
Yes, sir.
And again, are you planning on getting an attorney to represent yourself?
I'm gonna keep trying to get one. So far, I haven't had much luck. I got my money tied up with other personal things, so. so
All right,
far-
well, in terms of representing yourself in the case, if that's what you're going to do, Mr. De La Cruz, probably a good idea to go to the DA's office and get discovery in the case to find out exactly what sort of evidence they have and to kind of prepare for that if the case in fact does go to a trial.
Yay, Jude.
But it also sounds
yay.
as though you may still get an attorney to represent you. Is that right, sir?
Yes, sir.
All right, well, did you want to waive speedy trial here today, Mr. De La Cruz, so we can reset the matter, maybe give you some more time to get an attorney on the case?
Yes, sir.
Did you want to do that today freely and voluntarily?
Yes, sir.
All right, I do find a waiver of speedy trial by Mr. De La Cruz based on the circumstances. We'll vacate the jury trial we had set for November the 17th. We'll go ahead and reset this for a status/entry of appearance of counsel date, because then we can see if you're getting an attorney at that time, Mr. De La Cruz. And if not, then we can just go ahead and reset the matter for trial then.
Okay.
So with speedy trial being waived today, we'll see what date we can clear for that. December
Thank you,
12th at
Jude.
8.
Thank you. Thank you.
And again, the jury trial November 17th is vacated. All right, sir, any questions about any of that?
No, sir.
Good luck. We'll have you step over here, sign your setting slip, and get you on your way. Take care. This is 25T 1293, People of the State of Colorado versus Crystal Labate.
And Joe Schuyler on behalf of the people.
Luke Chang for Miss Labate, who appears at the podium in the courtroom.
All right, thank you. Is it Labate? Is that how I say that, ma'am?
Yes.
Okay, good morning, Ms. Labate.
Good morning, Your Honor.
Set for a pretrial conference today, not seeing a disposition. Mr. Chang, how would you like to proceed?
Yes, Your Honor, we're requesting a waiver of the court date, or we're requesting a continuance of the court date with a waiver of speedy trial. I'm still speaking with Mr. Porter, hoping to improve the offer in the case.
Is there any objection to resetting it for a continued pretrial with a waiver of speedy?
No, Your Honor.
All right, and Ms. Labate, sounds like you want to waive speedy trial here today, ma'am, to have the case reset. Is that what you want to do?
Yes, yes.
Are you
sir.
doing that freely and voluntarily, ma'am?
Yes, sir.
All right, thank you. Do find a waiver of speedy trial. And based on the record and no objection, we'll reset it for a continued pretrial. And we'll see what date we can clear. December 11th at 10. And that works, Mr. Chang?
Yes, Your Honor.
That works for you, Ms. Labate?
Yes, sir.
Okay, ma'am. We'll have you sign your setting slip for that date, and then we'll get you out of here. Take care.
Okay, thank you.
This is 25M 4124, People of the State of Colorado versus Victoria Sanchez Martinez.
Raquel De Los Santos for the People Practicing the Student Practice Act.
Thank you.
Robbie Nikon on behalf of Ms. Sanchez Martinez. She joins me at the podium to my right.
Thank you. Good morning, Ms. Sanchez Martinez. Set for a motions hearing today. Motion to suppress was filed in the case. And are we ready to proceed on that motion?
The people are, Your Honor.
Mr. Nikon?
Yes, Judge.
Okay. You want to have a seat then at council table with your client? And specifically, what are you seeking to suppress, Mr. Nikon?
Any of Ms. Sanchez Martinez's statements, any observations that the officers made after they had separated her away from the family and had found out from other witnesses that her narrative that the alleged victim here had stepped on her phone and I think kind of falsely imprisoned her. Anything after the police learned that, they should have terminated the encounter. So we're asking to suppress fruits after that information came to light.
Okay, and that's the people's understanding.
Minor correction, it was keys, but not a phone.
Oh, sorry, keys.
Okay, with that minor correction. All right, people can call their witness.
Your Honor, the people would like to call Agent Ian McDowell.
Okay, I'd like him to come forward then. Okay, good morning. If you could please raise your right hand. Do you swear or affirm under the penalty of perjury that the testimony you give before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Please be seated.
Yes, sir.
Oh, yes, I'm sorry.
I was wrong. 100% wrong. So, I don't know about the guys in the blue that we saw. Like the one who went to jail. No. He was there too. These are all from the same jail. All these different colors. Okay, I don't really know about the red yet. But the upper left corner, when he just got up and went to the bathroom. I hope he washed his hands. And when he left, I saw him walk behind the guy right below him and over a little bit. So they're in the same room right there. And the last color that was sitting in that spot below was the dark blue. So I don't know about the red. But if you look behind his shoulder a little bit, that looks like a red blob. And I think that is her. The guy in the green. If you look behind his shoulder a little bit, you can sort of see some red. I think that's her. I think they're all in the same room right there.
If you want to maybe turn that microphone there so we make sure the record picks you up. I'll do the same.
Sure.
Okay, go ahead.
Good morning, Agent. How are you doing?
Well, thank you.
Alrighty. Can you please state your name and spell your last for the record, please?
This is Agent Ian McDowell. Last is McDowall.
And what is your current employment?
I am an officer with the Lakewood Police Department. Currently, I've been working for just shy of 3 years.
And have all those 3 years been with the Lakewood Police Department?
Correct.
Alrighty. And I want to direct your attention to the night of August 3rd, 2025. Do you remember it?
Yes,
Were you working that day
I was.
around 7:50 at night?
I was.
And did you respond to a domestic call at the Village at Bear Creek, 2622 South Miller Drive in Lakewood?
That is correct.
And this is in Colorado and in Jefferson County?
Correct.
And when you arrived on scene, what happened?
I first talked to the reporting party, our victim, Daniel. He was just north of the apartment complex. He told me that he had been assaulted and bitten by his girlfriend. He showed me, I could see a mark on his neck, which appeared to be a scratch mark. He then showed me a picture from I think it was 10 to 20 minutes earlier, where the scratch mark was a little more red and he had a bite mark.
And did you take photos of his injuries?
I did.
Okay. Your Honor, may I approach?
Sure.
How are we lucky enough to get 2 biters in one day? Why bite, guys? Why bite? I just don't get it.
Do you recognize those?
Yes.
What do you recognize them to be?
This is the scratch mark on the neck. And then this was the bite mark.
And is this a fair and accurate representation of the photos you took of the victim's neck or the victim's bite mark and scratch?
Yes,
And you took these photos
I believe so, yes.
and they are a fair and accurate representation?
Yes.
Your Honor, at this point, I'd move to admit these as People's Exhibit 1,
Collectively or 1 and 2?
collective, or People's Exhibit 1 and 2, Your Honor.
All right, any objection to People's 1 and 2?
No, Your Honor.
All right, People's 1 and 2 admitted for purposes of this hearing.
So with the photos in front of you, what are the injuries that are seen by the photographs you took?
So on the neck, there appears to be 3 distinct scratch marks with redness and some slight skin tearing, but no obvious blood draw on this one. On the bite mark, it is on the arm with some pretty evident teeth marks in like a half circle, like a half moon.
Okay, and when you took these photos and you observed them on August 3rd, what did that lead you to believe?
It led me to believe that the victim had been almost for surely bitten and had some sort of scratch because of the way they're spaced. It made it look like fingernail marks, like if you had 2 or 3 hands out or fingers out like that.
Okay, and after you took these photos and you spoke to the victim, what did the victim tell you had happened to him?
He was visiting his girlfriend who lives in the complex. They were at the pool area. There was an argument. He asked for an Uber. She got him one. He then missed it, came back to the pool, asked for another one. Another argument ensued, and he said that she got very mad at him, at which point he was scratched and bitten by her.
And after he told you that, what did you do next?
After getting his story and getting the pictures, we went to go talk with the girlfriend.
And who is the girlfriend?
That was the Victoria, which is the defendant.
And do you see her in the courtroom
Absolutely,
today?
yes, I have.
Yes.
Vacation, not an issue at this hearing.
And when you spoke to the defendant, what did she tell you had happened?
She said there was an argument at the pool. It started because her little cousin had gotten sick and was causing a scene. He had asked for an Uber. She did provide one. He left. He then walked back a few minutes later saying that he couldn't find it. And he also may have, or she had mentioned that he was concerned that she had canceled it maybe on him. She denied that. He asked for another Uber or for her to take him home because he lives in North Glen, which is quite far from the LOI of the incident. She denied it. There was another verbal altercation. She told me that her keys during this had fallen on the floor. He then stood on the keys. She got extremely upset at him, was mad. She thought that he was doing this
I
on
don't
purpose
know.
to make her mad, at which point she scratched and bit him.
Do you wear body worn camera as
Yes.
part of your job?
Yep.
And were you wearing body worn camera that day?
Yes.
And have you had a chance to review the body worn camera footage from that day?
I have.
And you reviewed it today?
Yes.
And how do you know that you've reviewed it today?
When I walked in today, I was given a flash drive for my body worn camera and I reviewed those clips.
And did you initial or sign it with today's date?
Yes, it should be my name spelled out, my badge number, today's date, and then my signature.
At this time, Your Honor, I move to admit People's Exhibit 3, body worn camera footage from Agent McDowell.
Any objection?
No, Judge.
All right, People's 3 is admitted and you may publish.
Oh, that's when he called the cops. Because he was like, oh, you hit me.
Yeah. So because so obviously he's way over in the corner because I talked to him first. What's up with his neck and his arm?
I bit him
Why did you bite him?
because I'm being honest, I bit him.
Okay. And then what happened?
Bless you.
Thank you.
So we just saw body worn camera footage. What did the defendant's temperament reveal to you about this?
She seemed pretty relaxed when I was talking to her about it, and she was just telling me what happened during the incident. Like she said, I on the camera says I bit him, and asked why, and she said, I just being honest, I bit him.
And at any point when you were talking to the defendant, were there other people around?
Yeah, and that clip, that was one of her close friends that was also at the pool, And this is right outside her apartment where her uncle was, and I believe one other person, but I do not remember for sure. At least 2 people.
And did the close friend make any statements to you?
No, I believe she spoke mostly with my other partner.
And did you speak to anybody else on scene that day?
No, I spoke. After the arrest, I briefly spoke with the uncle, kind of explaining what was going on and why we were arresting. But mostly I spoke with Daniel, the RP, and then the defendant.
Thank you. Nothing further this time, Your Honor.
Cross-examination, Mr. Nikon.
Yes, Judge. Okay. It's Officer McDowell?
Agent, officer, it's fine either way.
Okay. So Officer McDowell, the first person that you spoke to was Mr. Martinez with respect to this case. Isn't that true?
That is correct.
Okay. And he told you that he was assaulted by his significant other. Isn't that true?
Correct.
Okay. He didn't mention any of the keys being on the floor, right?
I don't believe so.
Okay. He never mentioned to you that there was any struggle over the keys at all, right? He just focused on the claim that he was assaulted.
I believe so, correct.
Okay. And that's when he showed you his neck and his arm, right?
Correct.
Okay. And pictures of his neck and his arm are sitting before you
Yes.
on the bench, right?
Mhm.
Okay. Could you please take a moment to look at those two photos?
Mhm.
So first, with respect to the photo of the arm, you see some scratching, right?
On the arm?
Yes.
On the arm, I see just the bite mark and then the scratches on the neck.
Okay. So exclusively a bite mark on the arm and exclusively scratching on the neck.
Correct.
Okay. And those reflect what you saw in person that day, right?
Correct.
Okay. So after you spoke with Mr. Martinez, that's when you went to the apartment and contacted several other people, right?
Correct. I believe at least 3, maybe 4, but 3 I remember.
Okay. 3, maybe 4 people who were witnesses to this altercation, right?
It would have been just the one witness to the altercation. It was the Victoria, the main suspect was the person I spoke with, and then her friend was also at the pool, and that's who my partner talked with. Her name escapes me right now, but the friend in the video with the white shirt.
Does it sound like Jaleesa Ramirez? Is
Yep,
that a
yep, yep.
familiar name? Okay. So it was your partner that spoke with Jaleesa Ramirez,
Correct.
and you spoke with Miss Sanchez Martinez.
Correct.
And in order to facilitate your partner speaking with Ms. Ramirez and you speaking with Ms. Sanchez Martinez, you kind of moved them away from each other. Is that fair to say?
Correct. Yeah, when we first started, and I was talking to Victoria, her friend was there, and then once we kind of got more into it, and Jalissa had stuff she wanted to say, we then kind of separated, and then Agent Conway spoke with Jalissa, and I spoke with Victoria, some feet away from each other, some feet away from the apartment.
Okay. Would you agree with me that that movement where people are moved away a couple feet from each other, that was the result of a direction by you and your partner for them to move apart?
Yeah.
Okay. So when you spoke with Miss Sanchez Martinez,
Mhm.
you questioned her, right?
Mhm.
You questioned her about the bite mark to the arm and the scratch mark to the neck, right?
Yeah, I was asking about because I had already spoken with David and I had already seen marks. I had asked, hey, he has some marks on his neck. What happened?
And what she told you for the first time it came up that Mr. Martinez had stepped on her keys, right?
Correct. She said at the pool he was standing on top of her keys. This was some point during the verbal argument.
Okay. And that was consistent with what Miss Ramirez told your officer, that she was trying to retrieve her keys back when this altercation that resulted in those injuries occurred. Is that fair to say?
Yeah, I believe so.
Okay. During that conversation with Miss Sanchez Martinez, she and other people brought up that Mr. Martinez has a criminal history, right?
Yeah, I don't remember if that was brought up with Miss Sanchez. It was definitely brought up with the uncle shortly after, where he was speaking mostly to my partner about an incident that happened somewhere up north, I believe in Montana. It was
Okay.
like the main incident.
Could it have been Cheyenne?
Yeah.
Honor, I'm going to object to the relevance
I don't see the relevance of the alleged victim's criminal history to your motion, Mr. Nikon.
Well, Judge, the criminal history that I'm referring to is information that the officer learned that Mr. Martinez has been accused of falsely imprisoning my client before.
Oh, what does
So,
that have to do with your motion?
well, I believe that the officers should have terminated questioning when turned out that Ms. Sanchez Martinez said that she was trying to defend her property
Why? Why should he terminate questioning at that point?
because other people are corroborating an innocent account. My motion talks about some case law that stands for the proposition that when a person's innocence is abundantly clear, probable cause can be vitiated. So he should have terminated questioning when learning that the alleged victim has been accused of falsely imprisoning Ms. Sanchez Martinez before. And in this case, she claimed that she was just trying to get her keys back. She's a smaller person. She has a right to defend her
A
property.
general denial or a affirmative defense, Mr. Nikon, doesn't go to your motion, so the objection is sustained.
Yes, Judge. I have no further questions for this witness.
Okay, Agent McDowell, thank you for your testimony here today. You may step down.
Thanks, sir.
Anything further from the people?
Briefly with Agent Conway spoke with the other witnesses.
How
We're
is
gonna
that,
call-
how is that relevant?
Given Mr. Nikon's motion that, he spoke to Agent Conway can testify to the conversation that she had with the other people, the other witnesses, and, why ultimately they decided that there was probable cause to arrest the defendant for this
Not
crime.
particularly relevant, but witness is here, so if you want to come up to the witness stand and raise your right hand, do you swear or affirm under the penalty of perjury that the testimony you give before this court shall be the truth, the whole truth, and nothing but the truth? Thank you. Can you just tell us why you think you're here and what you did in this case, Agent?
Yeah, I got subpoenaed to testify for the DA's. on
And what
the-
did you
the
do in terms of your investigation in this case?
I responded to an address in reference to a third-degree assault domestic violence case.
And what specific actions did you take in terms of the investigation?
I spoke with the suspect's uncle as well as her friend.
And what information did you learn?
Uncle basically explained to me that he received a text message from the victim stating that her boyfriend or ex-boyfriend at the time was there, stating that he tried to take her keys. He confronted the boyfriend at that time as well. And then I also spoke with a friend who stated similar events, that they were at the pool, boyfriend tried to take girlfriend's keys, and that the suspect had scratched the victim's neck.
Did you ever speak with the defendant in this case?
No.
Any questions from the people in light of the court's questions?
No, Your Honor.
Any questions from the defense?
Briefly, Judge. So Agent Conway, you had mentioned in your conversation with the court, I think that you said that the victim had texted her uncle. Did I hear you correct?
The suspect.
The
That's what I'm
suspect
saying,
had.
Yeah.
Okay, understood. All right, nothing further.
Okay, Agent Conway, thank you for your testimony here today. You may step down. Thanks for being here. Any further evidence from the people?
No, Your Honor.
Any evidence on behalf of the defense, Mr. Nikon?
No, Judge.
Any argument, Mr. Nikon?
I'll stand on my motion.
All right, the matters before the court on the defense motion to suppress. In terms of suppression, that is a significant remedy that the court applies when there's been some sort of constitutional violation or violation of somebody's rights. I find no violation of Ms. Sanchez Martinez's rights here. The officer spoke to her, and I've seen the body cam footage, and Ms. Sanchez Martinez consensually spoke to him. That was a voluntary decision on Ms. Sanchez Martinez's part. She was not in custody. She was not under arrest, and a reasonable person in her position would not have believed themselves to be under arrest. She was not placed under any restraint. The fact that they separated the two individuals to speak to them separately does not give rise to a constitutional violation. It certainly doesn't give rise to an indication that Ms. Sanchez Martinez was in custody. And while there may have been some dispute about the facts between the alleged victim and Ms. Sanchez Martinez, that frankly is pretty much the case every single time we are going to have a discrepancy or a dispute between what happened. That goes to a defense at trial, doesn't go to a constitutional violation. I don't find any constitutional violation here. Ms. Sanchez Martinez made voluntary statements to law enforcement. Those statements are admissible. Miranda's not implicated because she wasn't in custody. And just because the officers may have had some information that the alleged victim had a criminal history, that doesn't give rise to a constitutional violation if they pursue an allegation from that person that they were assaulted. And then Ms. Sanchez Martinez essentially corroborates that by saying, yes, I did. Whether she has a valid defense to that for self-defense or defense of property, that's a trial issue, not a motions issue. So since I find no constitutional violation, no basis to suppress, the defense motion to suppress is denied. With regard to non-testimonial motions, has all impeachment information been provided to the defense?
Yes, Your Honor.
Can't imagine we have any experts endorsed in this case, but any experts from the people?
No, Your Honor.
No 404B motion has been filed by the people, so we don't seem to have that issue. People to provide a good faith witness and exhibit list to the defense at least 7 days prior to trial. And in terms of endorsement of defenses, the people are on
Malta,
notice
thank you so
of
much,
self-defense,
Malta.
defense
Thank
of
you.
property, and defense of others. Looks like those are all the motions we have pending. Any further motions from the defense?
No, Judge.
Motions pending from the people?
No, Your Honor.
All right, then, we are set then. Pretrial readiness December the 9th at 11, and a jury trial currently set for December the 15th at 8. Thank you. Good luck, Ms. Sanchez Martinez. Thank you. All right, recalling the Rose case.
Hayden Collard on behalf of Ms. Rose, who appears via WebEx from the Jefferson County Jail.
Did I miss someone?
Federal Center for the People practicing under the.
Did I miss someone? Did I miss you, Mel? Did I miss a thank you? I'll say thank you, but I don't know who. Actually, I should put it on top live chat, not top chat. Hold on, I think I missed someone. No, I got Jude, Malta, Jude. I think I, thank you. Whoever I missed.
Student Practice Act.
All right, thank you. Good morning, Ms. Rose. All right, we're here on a pending probation revocation complaint.
Good morning, Your Honor.
Are the people still pursuing the complaint?
Yes, Your Honor.
Mr. Collard, do you waive formal reading and advisement?
Yes, Your Honor.
How would you like to proceed this morning?
Your Honor, my client would like to make an admission to the violations in the complaint.
All right, thank you. So, Ms. Rose, my understanding, ma'am, is you want to admit to the allegations in the probation complaint. Is that what you want to do today?
I do.
And you understand by doing that, you are giving up your right to have a hearing. Did you want to give up your right to have a hearing?
Yes.
Have you had enough time to discuss the case with Mr. Collard?
Yes.
And are you satisfied with his advice?
Of
My
course.
apologies. Your Honor, she will not be admitting to the new law violation, which is still pending.
I
Are the-
will.
are
I
the
will.
people- hold-
I will.
Ma'am, hold on.
Okay.
Are the people still pursuing that allegation?
Yes, Your Honor.
Is that case still pending at this point?
May I have just a brief second?
Sure. I'll take one as well. Looks like that case is set for an arraignment in Division 4 on
Me
November
too,
17th,
Mel.
so it appears to
Me
still be a
too.
pending case.
Your
Yeah,
Honor, I'd like
yeah.
to correct. Your Honor, I'd like to correct the record. We are dropping the new law violation.
The people are withdrawing the allegation of a new case. So that allegation is withdrawn. And Ms. Rose, it sounds like then you want to admit to the remaining allegations of the complaint. Is that correct?
Yes, sir.
All right, ma'am. Did anybody force you, threaten you, or put any kind of pressure on you to get you to do this?
No, sir.
Anyone make any promises to get you to do this?
No, sir.
And today, are you under the influence of medication or anything else?
No, Your Honor.
So is your mind clear? Do you understand what you're doing?
Yes, Your Honor.
Is this a free and voluntary decision that you're making to admit to the allegations?
Yes, Your Honor.
All right, man. The allegations are that you did violate probation, specifically that you've had numerous failed random UA drug tests, most recent as of the filing of the complaint, were March 23rd of 2020, positive for amphetamines and THC, March 16th of 2020, positive for amphetamines, opiates, alcohol, and THC, February 20th of 2020, positive for opiates, amphetamines, and THC. Do you admit that that allegation is true?
Yes, Your Honor, but since then I've been clean, since,
We'll get there, Ms. Rose.
okay.
All right, next,
Yes.
ma'am. Again, as of the filing of the complaint, you would stop calling and reporting for all required random drug tests. That the last time, again, as of the filing of the complaint, that you called the random drug testing line was on June 9th of 2020, that you hadn't reported for a required drug test since March 23rd of 2020, and that you missed over 20 random drug tests in the past 4 months as of the filing of the complaint. Do you admit that that allegation is true?
Yes, Your Honor.
Next, that as of the filing of the complaint, again, you had failed to successfully complete drug and alcohol treatment and failed to enroll and complete inpatient treatment at the Aspen Center. Do you admit that those allegations are true?
I was in drug and alcohol treatment, but since COVID was in place, they had shut down the place that I was going to. So that's why I didn't finish the drug and alcohol treatment, but I was going every week when I was supposed to, like on time every week I was there. But because of COVID, they had shut down the place because everything was shutting down. So, and I couldn't find another place to that would take my Medicaid.
Mr. Collard, are we setting that allegation for a hearing?
Ms. Rose, are you admitting that you didn't complete drug and alcohol treatment?
Yeah.
Okay, so you want to admit to that allegation, Ms. Rose?
Yes.
All right, and finally, that as of the filing of the complaint, you had failed to report for a total of 11 probation appointments. Do you admit that that allegation is true?
Yes.
Counsel, anything further you'd like me to advise your client?
No, Your Honor.
The court finds that Ms. Rose has been advised of her rights. She's been represented by competent counsel and that she is making a free, voluntary, knowing, and intelligent decision to admit to the complaint, has not been subjected to any undue influence, force, threats, coercion, or promises, and is not under the influence of medication or anything else. Her mind is clear. She understands what she's doing here today. Court accepts the admissions, finding them to be voluntary. I do find a violation of probation in the case. With regard to resentencing, did the people have a position or any probation input this morning?
Your Honor, yes. In regards to probation's input, probation recommends that we close with jail time. I emailed Brittany from probation and she says that, that she wants this to be closed with jail time given the age of the case. And the people would echo the same sentiment. This is a 2017 case and the defendant has not been in compliance with probation as you've outlined just a moment ago. And so that, Your Honor, we would be asking to close this case with jail time. While we do note that the defendant says that she's making strides in sobriety, the complaint from probation from 2020, while August was, 2020 was the COVID era, by August, we had figured it out and how to make that work. And, they haven't had much contact with her since then. In addition to that, Your Honor, with regards to the defendant's criminal history, it's freezing. Your Honor, we would be asking to close with jail time. The action is freezing for me, so.
All right, thank you, Mr. Collard.
Yes, Your Honor. I have had a chance to review Ms. Rose's narrative from probation as recent as the day before our last setting. When me and Ms. Rose first appeared before you, Your Honor, you directed her to check in with probation She did check in with probation that day. She scheduled an appointment. Unfortunately, that first appointment she missed. However, she did show up to probation and speak with her probation officer. And it was evident to the probation officer that Ms. Rose was going through some sort of domestic situation. When the probation officer met with her, Ms. Rose had a black eye, and it was apparent that she was struggling with another situation. But I highlight that because she did make an effort to reestablish contact with probation. Your Honor, I'd point out, Your Honor, that Ms. Rose is a single mother taking care of 3 kids. Her oldest is 14. They live with Ms. Rose's mother, who is quite elderly.
I have 4 kids.
4 kids, excuse me.
Okay, ma'am, do not interrupt.
Your Honor, I'm told that Ms. Rose's mother is struggling to adequately provide for the children right now. Ms. Rose is the primary caretaker for her children. She walks them to school, she makes their lunch, she picks them up from school, as in walking them back. From what I'm told, Ms. Rose has everything she needs in her immediate vicinity. She walks to the store, walks to pick up her kids. And Your Honor, I'd return to the facts of the case. This is a violation of a protection order for alcohol use. I believe there was a domestic or a noise complaint filed at a residence that she was at, and no charge came of that actual report. But upon talking to Ms. Rose, she admitted that she had been consuming alcohol and there was a protection order in place. So I don't believe that the facts of this case are aggravated. So Your Honor, we would ask for 35 days credit time served in this case.
All right, thank you. Ms. Rose, is there anything you wanted to say or anything that you think I should know?
Yes, Your Honor. I just wanted to, admit and take responsibility for my actions. And like my lawyer said, it wasn't bad. I haven't drank since, like, I don't have no time to do drugs or drink or anything. I'm doing everything for my kids. My mother, she's 81 years old. She's pretty much bedridden. So my kids, I had to explain to Mr. Collard that my son's there in high school, and since I've been incarcerated, they've been having to go to school late and getting off of school early to go pick up their little sisters from school because they're too young to walk to and from school by themselves. And it's just really putting a strain on my family because I am the sole provider. They've been eating. My mother, she was like hysterical when I called her the other day saying, "Oh my God, they haven't been eating right. My kids are having to walk to the store." And I mean, I don't feel like that's safe for them to do. You know what I mean? I'm their sole provider. I'm their mother, and I feel like I should be there. And I'm on a jail sentence for Denver right now. I'm on ankle bracelet for 100 days until February 9th. So I'm begging the court, please, if you could run that concurrent. I'm only limited to, like, from my house, from a mile out to the store, to Plasma, to pick up my kids, to take my kids to school, and that's it. And it's all within a mile of my house. And if I'm just begging, please, if you could run that concurrent with my Denver 100-day jail sentence on ankle bracelet, I would so appreciate it. Because my kids need me, my mother needs me, and they're devastated without me out there. They don't have nobody else to take care of them. My brother, who would have been able to take care of them, I had a letter from my mom. They gave him 3 months to live, and so he's not able to help my mom at all no more because and I want to be able to spend some time with my brother before he passes. I've already had my oldest brother die in 2010 to suicide. And now I'm losing my next older brother to heart disease. So I just really want to be there for my family and just take responsibility for this case, and I apologize to the court for my actions. I mean, I shouldn't have been drinking.
love Canada. Love,
Honestly,
love,
I
love.
didn't know that I couldn't drink. I mean, I was just, I don't know what I was thinking. But I just want to take responsibility, and I'm sorry to the court. I'm done.
All right, thank you, Ms. Rose. This case dates back to 2017. Ms. Rose pled guilty to a Class 2 misdemeanor that was under the old sentencing statute, so potential is up to 1 year in the county jail. In terms of the facts of the case, it wasn't a particularly aggravated case. It was an alcohol-related protection order violation. So the facts of the case are not particularly aggravated. The complaint, in terms of the allegations that Ms. Rose admitted to, not overly aggravated, obviously just didn't comply with probation. And probation has been revoked and regranted, it looks like twice before, in 2017 and 2019. She does have that pending case that's still in the district court. That's a motor vehicle theft. And that's set for an arraignment, looks like in Division 4. Apparently she's serving some kind of a sentence on an ankle monitor out of Denver. I have no idea what that's about. And I cannot ignore Ms. Rose's actions last time she was in court when she appeared 6 hours late and was remanded. Her bond was revoked, and then she basically fled the courtroom and tried to get away. Had to be apprehended by deputies and brought back. So that's conduct, certainly that's offensive to the dignity of the court and the court system for Ms. Rose to attempt to flee after she had been remanded into custody. But she has taken responsibility for the probation violation today. Putting her back on probation makes no sense at all because this case has been going on now for 8 years. So probation is revoked and terminated unsuccessfully. Any outstanding fees or costs are referred to civil collections. Sounds like she has 35 days in terms of pre-sentence confinement credit, Mr. Collard.
That is my understanding, Your Honor.
All right, well, I will sentence Ms. Rose to 180 days in the county jail, giving credit for 35 days served. Alternative sentencing not authorized. And the case is closed. Good luck, Ms. Rose.
That wasn't nice. That wasn't nice at all what she did to that judge. This judge doesn't play around. He's just sending everybody to jail for months. All right, guys, we made it to the end. We made it. It's going to be a long day. It is, but we're going to get through it minute by minute. I shall see you all in OJ in a few minutes, or I will see you all tomorrow. I hope that you guys have a great day. Thank you so much for coming out, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh,